Any mention of urgent matters? Any mention for urgent matters?
Dear. No mention.
Supplementary list, pronouncement of judgment, item number 1.
Though it has been reiterated and held in various judgments that the date of entry into a service is the safest rule to follow while determining the necessary seniority between one employee or the other, however, the circumstances such as in the present case, where there is the presence of rules framed under Article 309 of the Constitution, which creates a distinction as provided in Rule 29(1)(b, the contention that respondents of 5, 6, and 7 were not born of service cannot be accepted in the presence of a specific rule. Moreover, the interpretation of petitioner to bring in a date of formal appointment into Rule 29(1)(b cannot be accepted, as this factor is clearly not present in this rule. The judgments placed by the counsel of the petitioner therefore have no assistance in the facts of the present case. Yes, for the following reasons, there being no case made out for any interference, incident petition stands dismissed.
Hello. Any mention?
Your Lordship, may I please, Lordship, I beg to mention item number 16.
16.
Yes, Your Lordship. I'm asking for two weeks time, Your Lordship.
You on behalf of?
Petitioner, Your Lordship. Petitioner.
Who's his name? Mr. Day?
Yes. Objection, Your Lordship.
2 weeks, right? Okay.
Must oblige, Your Lordship.
Supplementary list, item number 2.
What's our petitioner? Yeah?
A.S. Pandey will be appearing through VC, Lordship.
Who?
Aditya S. Pandey.
Doesn't look like yes, Pandya.
I'll inform. Oh,
Who's
he's there.
appearing?
He's there.
For the petitioner, Mr. Banerjee is there. Before the respondent.
Respondents.
Well, for the responding one, opposing one to civil petition.
Where's the petitioner?
His name is.
Oh, you're there, yes. Yes, what is this?
Your Lordship, this is a revision petition under section 115 of the Civil Procedure Code, challenging orders passed by the Commercial Court, which are at page 33.
115 against the Commercial Court order?
Yes.
Yes.
Your
Yes.
Lordship, this is these proceedings are execution proceedings, and we had sought implement of Ministry of Road Transport and Highways in these proceedings, in as much as the entire project which was being executed in the present case was being executed on the financial, administrative and technical sanctions of...
So what happened? What happened in implementation application then? What happened?
The commercial court rejected that application, or even though admittedly all the payments in the present proceedings have been made by MORTH, rejected the application solely on the ground that MORTH is not part of the arbitration agreement, and therefore the matter has been decided by the arbitral tribunal once, and MORTH cannot be now included in the execution proceedings. My submission to that effect is, Your Lordship, that arbitration proceedings and execution proceedings are completely different. Arbitration proceedings are governed by the arbitration agreement between the parties.
Yes.
And if a party does not is not a signatory to the arbitration agreement in terms of Section 7 of the Arbitration Act, then it cannot be implemented. However, the Arbitration Act in Section 35 and 36 creates a distinction and says that the execution proceedings will be governed by the CPC. And execution proceedings, in a way, are akin to a suit, in as much as execution of the award is concerned. And all necessary and proper parties have to be included. And it is in the best interest of the respondent itself if Ministry of Road Transport and Highways is included in these proceedings, because ultimately they are the party who have been making payments in this project. So if you Lordship come to page 33.
Yes.
33 is the order passed by the learned commercial court, and if your Lordship sees the fourth paragraph, the learned counsel of the judgment debtor objected to the execution on two grounds. First, that the arbitration award is not stamped, and second, that the award is to be satisfied by a third
Where are you reading from?
MORTH and prayed that the notice may be issued.
Please, one second, Mr. Pandey. Where are you reading from? Page 33? Or is it 10-8-23?
I apologize, Your Lordship, it is at page 30. I apologize.
Then don't go like a train, just... Yeah, slowly, yes. Now, what were you reading?
It's at page 30 and order dated 26th of June 2023.
Okay.
Your Lordship may see the fourth paragraph.
Yes.
And this is learned counsel for the judgment debtor objected to the execution on two grounds. One, that the award is not stamped, and second, that the award is to be satisfied by a third party, i.e. MORTH, and prayed that notice may be issued to MORTH. And Your Lordship can see at page 31 over the page the conclusion of the commercial court. After quoting 46D, the learned commercial court says that in this regard, issue whether MORTH is a necessary party to the arbitration proceedings has already been decided by the learned arbitrator confirmed in application under Section 34 of the Arbitration and Conciliation Act, and further in application of Section 37 of the Arbitration and Conciliation Act. Now, my submission to that effect is that whatever happens in Section 34 and 37 is not conclusive as far as the execution proceedings is concerned. And this consideration of the commercial court of the orders passed under Section 34 and 37 is not a relevant consideration when it comes to execution of an award.
Yes.
And Your Lordship can see in this regard the Arbitration Act. Your Lordship sees Section 2B. Section 2B, Your Lordship, defines arbitration agreement, and it says that arbitration agreement means an agreement referred to in Section 7. And Your Lordship may also see Section 2H, which is party. Party means party to an arbitration agreement. And then finally Section 7 your Lordship sees section 7, it says that in this part, arbitration agreement means an agreement by the parties to submit to arbitration all or certain disputes which have arisen or which may arise between them in respect of a defined legal relationship, whether contractual or not. And clause 2 says arbitration agreement may be in the form of an arbitration clause in a contract or in form of a separate agreement. And clause 3 finally says that arbitration agreement shall be in writing. So as far as the arbitration agreement is concerned, because it is a consensual agreement between the parties, it is required that it shall be in writing.
Yes.
However, the Arbitration Act creates a distinction when it comes to execution proceedings, and your Lordships in this regard may see section 35.
Yes. Yes.
Yes. Your Lordship, 35 says finality of arbitration awards. It says subject to this part, an arbitral award shall be final and binding on the parties and persons claiming under them respectively. And this expression, persons claiming under them respectively, has been interpreted by the Honorable Supreme Court in Chair Properties, where Supreme Court has gone on to say that even parties who are not part of the arbitral proceedings are bound by the arbitral award, and they can be implemented as far as execution proceedings is concerned.
Okay.
And your Lordship may now see section 36(1).
Yes.
So 36(1) says in postpaid, where the time for making an application for to set aside the arbitral award under section 34 has expired, then subject to the provisions of subsection 2, such award shall be imposed in accordance with provisions of Civil Procedure Code 1908 in the same manner as if it were a decree of the court. So my proposition here is that as far as the execution proceedings is concerned, when it is an admitted fact, and the documents are there in my petition, I can take your Lordships to that document as well. It is an admitted fact that it was a project concerning the national highways. National highways west in the Union, and in the present case, all sanctions in the respective projects have been made by MORTH, which is Ministry of Road Transport and Highways. I say that whatever has happened in as much as section 34 and 37 and in the arbitration proceedings is concerned, regarding implement of Ministry of Road Transport and Highways becomes immaterial when it comes to the execution proceedings. And execution proceedings has to happen in respect of a party which is actually the beneficiary of the project and which is actually making projects which is actually making payments in respect of this project. Now, your Lordship may in this regard just see one judgment of the Honorable Supreme Court, that is Chair Properties, one paragraph of this judgment. My colleague is there, will just supply a copy of the judgment, one paragraph, para 29. This is 2018-16 SCC 413.
What is this? This is a different. Charan Properties.
Yes. This is Charan Properties versus Kasturi and Sons. And
Yes.
your Lordship may first have section paragraph 8, where the issues have been defined. The first issue, your Lordship, is that whether an order of interim injunction can be passed against the respondents who are not parties to the arbitration agreement or arbitration proceedings. So in respect of this matter, the parties had proceeded against certain parties who were not a part of the arbitral proceedings. And then finally deciding this issue, the Supreme Court decides this issue finally at paragraph 29. 29, your Lordship, says that the decision in Indowind arose from an application under Section 11 of the Arbitration and Conciliation Act 1996. Indowind was not a signatory to the contract and was held not to be a party to the arbitration agreement to refer the disputes to arbitration. Indowind held that an application under Section 11 was not maintainable. The present case does not envisage a situation of the kind which prevailed before this court in Indowind. The present case relates to a post-award situation. The enforcement of the arbitral award has been sought against the appellant on the basis that it claims under KCP and is bound by the award. Section 35 of the Arbitration and Conciliation Act 1996 postulates that an arbitral award shall be final and binding on the parties and persons claiming under them respectively. The expression claiming under is ordinary meaning directs attention to the source of the right. And then, Your Lordship, finally, Section 35 is quoted. And then over the page at placetum A, the expression person claiming under them is a legislative recognition of the doctrine that besides the parties, an arbitral award binds every person whose capacity or position is derived from and is same as the party to the proceedings. So this is, as far as the law is concerned, the commercial court was bound to consider that these proceedings being separate from the arbitral proceedings, whether MORTH is a necessary party or not. Just a few documents, Your Lordship, and then my learned senior can take over. Your Lordship may in this regard just see page 35 of the petition.
You have come against how many orders?
Your Lordship, the first order is that of 26th of June 2020, which is at page 30. Your
Okay,
Lordship
35. What is 35?
And then there is a consequential order of granting further time, and finally, my chief engineer has been asked to show cause that why he should not be sent to prison, as if the chief engineer has to pay from his own pocket. The order dated 10/8/2023.
Yes.
Your Lordship can see at page 33 and over the page at 34.
Yes.
That 2 weeks to satisfy the decree failing which the chief engineer NHPWD Roads shall file his show cause as to why coercive action by way of detention in civil prison should not be taken against him for failure to satisfy the decree.
Yes, so show cause why on 28th. That's all, yes. Yes.
Yes. So my case is, first of all, I am not the right party as far as this execution is concerned. When I am asking MORTH to be impleaded so that
Yes.
the execution can be eased, you do not implead MORTH and then finally put the chief engineer in respect of this project in civil prison. Now, Your Lordship, in this regard, just see page 35 of the petition, which is the letter of acceptance.
Yes.
Your Lordship may note that this letter of acceptance, the first paragraph says that this is to notify that your bid for execution for the work of two-laning of Nongstoin Shillong section of National Highway 44 and Nongstoin Shillong Tura Road in the state of Meghalaya under phase A of SARDP-NE. SARDP-NE, Your Lordship, is Special Accelerated Road Development Program of Northeast, which is run by MORTH. At the contract price of 1303.8345 crores only is hereby accepted by the department. Now, this entire policy belongs to MORTH and 1300 is the initial contract price. Now, what happens subsequently, Your Lordship will see that
Where's the agreements here? Yes, page 37.
There are agreements, but I'll straight away take Your Lordship to page 63. because the meat of the matter here is who pays in respect of this contract. And page 63 is the revised cost estimate, which your lordship sees the heading Ministry of Road, Transport and Highways.
Yes. Yes.
And this is subject your lordship sees is second revised estimate for two lading of Shillong Nongstoin section of NH 44E, and so the description is given, and thereafter over the page at 64 at your lordship sees that the revised cost estimate of 2158 crores has been approved by MORTH.
Yes.
So the payments in respect of this project were being made by MORTH.
Yes.
Now your lordship sees that at page 67, I'll just flag. Page 67, your lordship sees that again this is a document of Ministry of Road Transport and Highways, and just the subject your lordship sees is minutes of the meeting under chairmanship of so and so held on so and so to review the status of implementation of 3 BOT projects under Arunachal Pradesh package and revised estimate of second laning of Shillong Nongstoin Tura under phase A of SARDPNE. So not only financial sanction, the status of the implementation of the project was being constantly monitored by Ministry of Road Transport and Highways. And finally, I will take your lordship to page 82. Your lordship is the invocation letter as far as the arbitration agreement is concerned. And your lordship sees that subject to laning of Shillong Nongstoin section of 44 NH 44E Nongstoin Tura so and so. Reference is of the letter, and thereafter the content of the letter says, please refer to your letter cited under reference, forwarding therewith your letter dated so and so, enclosing therein minutes of meeting for decision of the DRB on claim of contractor regarding delay, disruption, prolongation costs held at New Delhi on 24th and 25th of September, and requesting the ministry to appoint arbitrator for the above mentioned project. Para 2, in this regard, it is to state that with the approval of the competent authority, Ministry has nominated Mr. So-and-so as our arbitrator to represent Ministry and State PWD, Meghalaya, for the above work. And then the description of the arbitrator is given. So the Ministry gave financial sanctions, reviewed the project, the entire project belonged to it, and it also appointed the arbitrator.
What's the award? What's the amount of award?
The award, your lordship, is of 75 crores.
Okay.
Plus interest.
Yes.
And your lordship can see thereafter, I'll just take your lordship to one order and then directly to the award, because the award itself is based upon admissions interstate between the petitioner and MORTH. So, your lordship can see the first hearing happened in this matter at page 89. And your lordship can see that MORTH was such a necessary and proper party that if your lordship sees for the respondent, first your lordship can leave the second, Mr. Ashish Kumar Pandey and Mr. Anshuman Aaron, advocates, Ministry of Road Transport and Highways, for short MORTH, Government of India. So, such is the amount of deep and pervasive involvement of MORTH that even notice was issued and they were present on the first date of hearing. Although the issue of the impleadment was raised later and decided. But this shows that MORTH was a necessary and proper party to the agreement. Now, your lordship, directly to the award. at page 99. This is an award dated 27th of July 2021.
Page 99.
99, Your Lordship. Annexure 17, page 99. Your Lordship, I may just highlight, if Your Lordship sees paragraph 1 at page 100. This is an award which has been passed under section 31(6) of the Arbitration and Conciliation Act, which is for passing an award, a final award at an interim stage. The order shall dispose of application dated 30/5/2019 filed under section 31(6) of the Arbitration and Conciliation Act 1996 by the claimant praying to pass an interim award prior to the adjudication of other claims under the statement of claim, calling upon respondent to make payment of amount 117 crores 97 lakhs 18,006 rupees being the amount towards claim number 1. So this claim was made upon certain admissions, and the claim finally has been allowed to the extent of 75 crores. Now Your Lordship sees paragraph 27, which records the contention of the claimant. Just one paragraph. Paragraph 27 at page 105.
Yes.
It says, regarding the above decision by DRB1, no dispute, even an intention to raise a dispute was raised within the statutory period of 28 days, rather through letters dated so and so and so and so addressed to the Ministry of Road Transport and Highways, the respondent clearly admitted to its liabilities and agreed with the amounts awarded in favor of the claimant by DRB. Now, this claim itself was based upon certain admissions made to the Ministry of Road Transport and Highways, and finally Your Lordship would see at page 119, paragraph 78.
Yes.
Paragraph 78 says, and this is the finding of the arbitral tribunal. The arbitral tribunal itself relies upon certain correspondences between petitioner and MORTH. Since respondent did not settle the payment due to claimant, it by letter dated so and so approached DRB stating therein, and Your Lordship will see the quoted part, with reference to the subject cited above, I have the honor to inform you that the payment due to the contractor could not be settled in total, as there are no provisions in the sanctioned revised cost estimate, but the amount kept for estimated purpose of rupees so and so for labor cess has been processed and on payment and submitted to RO Guwahati. RO Guwahati is Regional Office Guwahati of MORTH. And finally, at 79, also this has been highlighted from the above letter dated so and so sent by the respondent DRB1. It is patently clear that the amount kept for estimated purpose of so and so for labor cess has been processed on payment and submitted to RO Guwahati. So the correspondences in respect of MORTH, which is the payment making authority, has been relied upon in passing this award, and the conclusive paragraph Your Lordship will see at page 105, which is the final paragraph.
105?
Award 103, para 103 at page 129.
Yes.
In the circumstances mentioned above, the tribunal decides to award a sum of rupees 75 crore to the claimant pending detailed certified calculations. The amount is the one which is mentioned before DRB1 and also gets mentioned in the correspondences exchanged between the claimant, respondent and MORTH. So
Yes.
my case is, if the award itself has been passed on the basis that there are certain admissions in respect of correspondences with the payment making authority, which is MORTH, then it is all the more necessary that MORTH is impleaded as a party respondent in the execution proceedings, and the award may be satisfied by the MORTH.
I'm sorry, just to interrupt my learned friend, if he also reads the last portion of paragraph 103. Just last portion.
The respondent is directed to make the payment of the aforesaid interim award within 3 months.
Yes.
That is all right, Your Lordship. Now, that is all right, but in the present case, it is nobody's contention that the payments were made by respondent from its own pocket, or rather the petitioner in the present matter. The amounts which were given for sanction have been treated as admissions in passing the award, and therefore this award has been passed against the petitioner in the present matter.
Okay, Mr. Pandey, one thing. There's an office note here. I saw it earlier. You have not annexed separate copies of the orders.
Your Lordship, we had applied. There is an application for.
Then where's an application to dispense with a third copy for a time being?
I apologize, Your Lordship. I was under the instruction that we will file an application for exemption from filing of the certified copy because we had filed.
That's not on record.
Your Lordship, then we'll request that the matter may be taken up tomorrow. We'll place the application on record.
Tomorrow?
Because
tomorrow?
On Monday, Your Lordship.
May I just make one submission, my Lord, on
yes.
this issue, my Lord, if my Lord permits me. My Lord, I am appearing, my Lord, for the respondent. My Lord,
yes.
I am really surprised that, my Lord, a state litigant, my Lord, goes to this extent, my Lord, to try and, my Lord, avoid making, my Lord, payment of, my Lord, to the dues. My Lord, I'll just take, my Lord, 3 minutes of my Lord's time, 5 minutes, my Lord, at most, my Lord, explain the situation. My Lord, there is an award of 27 July 2021, which directs the respondent, which is, my Lord, the appellant here, the revisional petitioner here, my Lord, PWD department, my Lord, to make payment of 75 crores to us. This award, my Lord, was challenged. The award, my Lord, that's why I showed, my Lord, page 10, paragraph 103 at page 129. The award is against them.
Yes.
My Lord, this award was challenged under section 34. Both the fact of this award being passed against PWD as well as the fact that they had made an application for adding the Ministry of Road Surface Transport, MORT, in the arbitration proceeding, both were considered and section 34 application was dismissed, which means the award stands. They had preferred a section 37 appeal from that order. The Honorable Chief Justice Division Bench dismissed it with 10 lakhs cost.
Okay. That order is not here, the 34 or the,
No,
37 order.
My colleague has one of those orders there.
Is there?
But also
yes, sure.
from the order. I'll just give the all the orders. Also, from the fact that they wanted more to be added, they also preferred an independent appeal under section 37, which was also dismissed. Also dismissed by an order of 15 May 2023. That is also there. So this argument which my learned friend makes have not met with success for the last 5 times. And section 37 appeal has been dismissed with cost of 10 lakhs. Now kindly look at the impugned orders also. In the impugned order, my learned friend client undertakes to make payment. Kindly look at pages 30. I'll just come back to the other orders I referred to, but kindly first see the impugned orders at page 30. Kindly have a look at the impugned order first. I'm surprised the state goes to this level where we expect the state to be fair. Kindly see 26 June 2023.
Yes.
Decree holder is represented. Judgment dated. Then learned counsel for the decree holder submits in view of the judgment dated in arbitration appeal number 6 of 2023. Decree may be executed by directing the judgment debtor to satisfy the decree as the judgment debtor has already exhausted the remedies provided in the arbitration conciliation act. This is section 37 appeal being dismissed. Learned counsel for the judgment debtor objected to the execution in 2 grounds. Award is not stamped. and that the award is to be satisfied by third party mod and paid for notice may be issued to mod. In this regard, learned counsel relied on order 41 rule 46D. With regard to first leg of submission, learned counsel for the decree holder submits stamp and paid. No dispute. Then kindly see next. With regard to second leg of submission, it may be stated here that order 41 rule 46D CPC provides for the procedure when death comes to third person's relevant portion is reproduced below. No, that is not relevant here for the present, because I am not asking against third party. The judgment debtor has tried to impress upon this court that the mod is the principal and state PWD is merely the executor of the project. In this regard, the issue whether mod is a necessary party to the arbitration proceedings has already been decided by the learned arbitrator, confirmed in the application under section 34 of the Arbitration and Conciliation Act, and further in the application under section 37. This will be appealed. And all those orders are there. My colleague will give a copy of the arbitration. Therefore, this court is of the view that this leg of objection raised by the judgment debtor is no longer in dispute. Further, an executing court cannot go behind the decree when the decree specifically is against the PWD government of Meghalaya. This court is not inclined to accept the objections raised by the learned counsel for the judgment debtor. Judgment debtor is hereby directed to satisfy the order award along with cost of rupees 10 lakhs within 1 month from the date of this order.
The cost 10 lakhs by division bench, you mean?
Yes.
Yes. You file an application. Yes.
Next, 27 July. Judgment debtor then the court in commercial miscellaneous case number 4 of 2020 has rejected the prayer of the judgment debtor for stay. Learned counsel for the judgment debtor thereafter praised learned counsel for the judgment debtor therefore praised that 4 weeks time may be given to the judgment debtor to satisfy the decree.
Yes.
Learned counsel for the decree holder will be objected to the prayer stating that it would amount to granting a stay and submitted court may consider 1 or 2 weeks time be given to the judgment debtor to satisfy the decree, but learned counsel given 2 weeks time to satisfy the decree. Then next, kindly similar 10th August. After the first 4-5 lines, learned counsel for both sides informed the court that the SLP has been dismissed. This is from the 37 appeal. One of the SLP is dismissed, and one of the SLP is confined to say that excess of 75 crores will be considered later, which was our SLP. Then learned counsel for the judgment debtor, Ms. Sansad submits, kindly see. Learned counsel for the judgment debtor, Ms. Y. Pallavi submits that the order has been communicated to the government and praised for 4 weeks time to make the payment. Learned counsel for the decree holder submits that the judgment debtor has been given sufficient time to make the payment, but has time and again delayed in payment, prayed that show cause may be issued to the chief engineer to show cause as to why course of actions by way of detention, civil prison should not be taken against him for failure to satisfy the decree. Then heard learned counsel for the parties, judgment debtor has been granted 4 weeks time to make the payment, another extension of 2 weeks was granted to satisfy the decree. However, till date the decree holder has failed to make the payment. However, since the judgment debtor is ready to make the payment, and already 6 weeks have been granted by them to make the payment, this court hereby grants the judgment debtor further time of 2 weeks to satisfy the decree, failing which the chief engineer shall file a show cause as to why course of action may not be taken should be answered. And it's fixed on kindly see 28 August 2023 for payment. So now after 10th August, the state now prefers a civil revision petition. I don't know how much a 115 revision petition will also lie. From the execution itself, from a commercial court execution application. But this is what they do to stall the date of 28th August when they have to go and stay. And the undertaking, they also represent to court that yes, we want to make payments. And all the issues with mod. Because today, I am not interested in what, if I have to pursue a third party to execute my decree, I shall do that, that's a different issue. Today, the party to the agreement has seen is PWD. Yes. The award, the arbitration proceeding, they are the respondent. The award at page 103, it is PWD. That is at page 129. That's what I just interrupted only there to show. My learned friend, with the greatest respect to him, read everything else but to show that the award is against respondent. If the section 34 now stands dismissed, 37 is also dismissed, where is the question? PWD is the only party. And made good the award, and that is why they also went and undertook that they will make payment. Now, kindly look at there are two orders which, if kindly looks at the 15th May 2023 order.
15th May, where is that order?
There is a, yes, that is a section 37 appeal which they had also preferred. There are three orders which I would like request my lord to just have a look. 15th May 2023, that's a commercial court rejecting section 37 appeal.
May.
Yes, kindly look at paragraph 1 of this.
Is 17th or 15th?
There are two orders. 15 May is the section 37 from the order rejecting the addition, implement. The 17th May is the section 34 petition.
The 17th, 15th not here for us.
Oh, I'm sorry, then kindly take 17 May. That is also. Kindly look at 17 May also.
Yes.
And kindly look at paragraph 1. This is an application under section 34 as that, paragraph 1. Read with section 16(6) of the application, whereby two orders are under challenge before this court. By the application under 34, petitioner is seeking quashing and setting aside of the interim arbitral award dated 27 July, whereby the arbitral tribunal has allowed the application under 31(6) and passed an interim order in favor of the claimant, herein responding to the tune of 75 crores. And by the same application, petitioner is also challenging the order dated 21st March 2020, passed by the arbitral tribunal, rejecting the application petition under section 16 of the Arbitration and Conciliation Act. This is one question of jurisdiction. Then, all this is discussed, and kindly, come to paragraph 65.
65.
Yes, that's the last finding paragraph I just told you.
Internal page? Okay, got it, yes.
I'm sorry.
Page 135.
Yes.
Last page.
Further, this court unable.
Yes. Further, this court is unable to.
But if the court understand correctly, it's interim awards, it's an undisputed amount, correct?
Sorry, Malad?
The interim award is on the basis of undisputed amount, which had been educated earlier.
Correct. Correct.
But this matter has come before this court once. Yes, I think, or twice.
In fact, this matter has been decided by your lordship twice. And once the respondent had come under 227, and the other time we had come challenging an order which framed an issue over the entire 117 crores again.
Okay.
And the order,
yes, Ms. Banerjee, continue.
Passed by the Supreme Court will have some bearing.
This is with regard to the 75 crores, the undisputed amount.
Yeah.
Can you see paragraph 65? Further, this court is unable to find fault with the findings of the learned tribunal when awarding rupees 75 crores in interim award. It may be mentioned as petitioner has never challenged the calculation submitted by the respondent. Hence, this court is unable to accept the argument advanced by the learned counsel petitioner. There was no reasoning in the order. Fourth leg of argument advanced by the petitioner is the non-implement of mort is against public policy and most basic notions of justice and morality, that is contrary to 34(2)(b)(2) and section 34(2)(8)(3). It may be stated herein that the implement of mort has been sought by the petitioner in its application dated 19 December 2020, which was rejected by the tribunal. Vide order dated 27 July 2021 and confirmed by this court in order dated, this is the order I was 15 May 2023 in commercial arbitration case number 14 of 2021. Hence, court deems it not necessary to decide this issue afresh. And my learned friend again raises the same point. In view of what has been discussed above, petitioner has failed to bring its case within the ambit of section 34 of the Arbitration and Conciliation Act. Application is thus without merit and hereby dismissed. And then this is also, kindly look at the 19 June 2023 order when it goes up to
yes,
the division bench before the honorable.
Yes. Where's the operative part?
Kindly see paragraph 1 itself to start the beginning of the judgment.
Yes.
This is a complete waste of time and a reckless exercise undertaken by an irresponsible appellant. The challenge here is under section 37 of the Arbitration and Conciliation 1996 to an order dated May 17, 2023, passed by the Commercial Court Shillong on a plea under section 34 of the Act, challenging an arbitral award rendered on July 27, 2021. The arbitral award was made on an application under Section 31(6) of the Act. Such provision empowers an arbitral tribunal to pass an interim arbitral award in respect of any matter that may be covered by final arbitral award. Appellant hearing engaged in goes into the facts. This is division bench. Then kindly come to paragraph 35 at the end. Should be internal.
Page 15.
14 of
40.
Yes. The court
of the first instance was perfectly justified in not touching the award. I'm sorry, my lord, may I just, I'm so sorry, my lord, may I just also trouble my lord with paragraph 34, just a paragraph before that.
Yes.
There are other specious excuses which are proffered and irrelevant references made in this matter which has been a complete waste of judicial time. Notwithstanding the contract being between the appellant and the contractor, a fact which is undeniable and is clearly admitted, the appellant refers to the correspondence it exchanged with the relevant union ministry and the advice that it is received from such ministry. In a contract between two parties, neither is governed by the conduct of a third party, whatever may be such third party's control over the other party. Indeed, an issue has been sought to be raised quite seriously that the Union Ministry of Road Transport and Highways was a necessary and proper party to the present proceedings. Surprises never cease. Such ludicrous assertion may probably be because the officials who are behind the appellant, who do not need to pay from their own pockets for their recalcitrance, and it is the taxpayers' money that is being squandered. Very, very strong language, my lord of the division bench, the Chief Justice. The court of the first instance was perfectly justified in not touching the award. The award rendered on July 27, 2021 is unimpeachable. It is based on clear and tacit admission on the part of the appellant. Appellant, my lord, is PWD. Herein, and the appellant could never have turned around to question its own admissions or seek to deny the payment of what was found by the EB on the dispute resolution board on February 19, 2017, including the decision of September 25, 2016, to be due and owing to the contractor. In making the interim award, which is an efficaciously executable as a final award, the arbitral tribunal has only given the contractor a part of its dues that had remained outstanding for a long time. Court of the first instance quite appropriately quoted the relevant paragraph from the impugned order with approval that the same did not call for any interference. Then, my lord, it has become fashionable. They go on. Then, my lord, kindly see paragraph 38. The real tragedy is not the appellant. As a litigant shying away from payment or its officials being too clever and a half, the tragedy is in the erroneous expert advice that is rendered to the litigants as the appellant. Arbitration in appeal number 6 of 20 dismissed with cause, assessed at rupees 10 lakhs, which will be paid over in addition to the amount awarded.
We'll pass orders then. Yes.
Your Lordship, I will just point to two submissions. Two submissions, Your Lordship, because
and the order is also not annexed. I'm surprised, that this is not. I'm sorry, but this is not a state who is a litigant. No, this is a state who is a litigant, and we are supposed to act reasonably and fairly. And this
absolutely. I mean, I don't understand why this, Mr. Pandey, why this order is not annexed? They're very relevant. I mean, why we don't annex? Because if you want a proper adjudication, then all the materials will be placed on record. It will be placed on record because.
I completely appreciate.
This is the question.
Your Lordship, but the list of dates mentions every order.
How do you expect? You expect the court to look for itself for these by itself for these orders?
Why? Your Lordship may just consider one.
They should have been produced in the first instance.
Your Lordship, if Your Lordship, if the matter proceeds, we will provide all the documents, additional documents, because the execution is listed on 28. That is why the petition has been filed in such urgency. Now, two submissions, Your Lordship, and that has to be considered the order of the Supreme Court dismissing the SLP, because whatever my learned senior has argued has been nullified by the order of the Supreme Court dated 7th of August 2023. If my colleague can share a copy of the
yes, I just got it just now. Yes.
Your Lordship just sees, because today the issue before this court is whether MORTH is a necessary and proper party to the execution proceedings. We are not discussing whether it should be a party to the arbitration agreement. Now,
Where were you reading from?
The order. I am reading the
Then may I
order.
not complete my, then may I just, before my learners, I just answer that point as well, if wants me to answer that point. Because today,
One second, let's examine the Supreme Court order first. This is dated.
Just
yes,
place the order of the Supreme
Yes.
Court, then my learned senior can take.
7th August 2023.
Right.
Your Lordship, when see the order dated 7th August, it is said that in SLP number 16223 of 2023, which is our SLP in respect of the award, after
Yes.
hearing the counsel for the parties, the court is of the opinion that no interference is called in the special leave petition number so and so.
Yes.
Accordingly, the special leave petition is dismissed. And now it is to be noted, all rights and contentions of the parties are, however, kept open.
Right.
So the reliance placed as far as the observations made by the division bench in the section 37 proceedings are of no relevance. Because the Supreme Court, after hearing the parties, has
Does not say that ruby is disregarded. Just says that it's still open, whatever remaining rights that you might have.
Why it
Order to confirm.
over the page, why it has been left open is also considered over the page, because your Lordship had decided that the question as far as jurisdiction of the arbitral tribunal to frame issue over a decided matter. The Supreme Court said, leave granted after hearing the submissions of the parties. The court is of the opinion that High Court fell into error by setting aside the entirety of the issue. By its impugned order dated so and so, issue number 31 is hereby directed to be recast. Is the claimant entitled to any sum in excess of 75 crores directed by the interim award dated so and so? Subject to the above alteration, the proceedings in the arbitration shall continue before the tribunal from the stage where they were before passing of the impugned order. Now, the issue itself is pending before the arbitral tribunal. And even as far as my SLP is concerned regarding the so-called admitted amount of 75 crores, the Supreme Court says in its order that all rights and contentions have been left open. So the fact of the matter here is, firstly,
How do you interpret all rights and contentions when the rights and contentions means you still survive after like all the multiple proceedings before the arbitral tribunal, before the division bench, before the commercial court?
Because
See what survives. Because the only thing is that you see, Mr. Pandey is more or less a mercy petition, asking for some time to satisfy the award. That's all. The amounts for seeking intervention at this stage and under 115, how far maintainable?
Your Lordship, the fact of the matter is that the issue today depends upon a particular cause of action. The claims are immaterial,
Whatever may be, but this has been thrashed and it has been discussed and it's gone up. 37 applications been dismissed also.
Now, your Lordship may consider one thing.
Yes, dismissed.
Just see one provision. Just see, your Lordship may see just one provision. Section 79 of the CPC.
Yes.
Because today execution proceedings will be governed by the Code of Civil Procedure.
Correct.
The mandate under the Arbitration Act.
Correct. No quarrel with that.
And section 79 of the CPC provides that in a suit against the government, the authority to be named as plaintiff or defendant, as the case may be in a case of suit against the central government, the Union of India.
Yes.
Now today, the National Highways under section 4 and 5 of the National Highways Act 1956.
Can we reopen that, Mr. Pandey? Notwithstanding what the Supreme, can we reopen that?
My submission is there is no question of reopening.
Then
what has been decided is decided in the context of the arbitration proceedings. Today, your Lordship has to decide whether
your main argument is that arbitral proceedings are over. They have an award in their favor. It's only the execution where maybe you still have some room to wriggle around. Like with regard to whether MRTH should be who should satisfy the decree? Who should satisfy the decree?
it may be so that I am not, my facts are not good enough to become a party to the arbitration agreement in respect of MORTH. But are they also not?
See, if you have the same arrangement as you had in execution of the project, you were signatory to the agreement with the respondent. Now, accordingly, that's how you try to achieve the funds again to satisfy the award. Why should it be their headache? When MRTH was never signatory to agreement. If you go by the CPC, it's who was signatories to the agreement, right?
And that's the your lordship. The agreement is with us by the respondent, PWD State of Meghalaya. I can't go against someone else.
No.
That's the award. That's the respondent that we need not paragraph 103. My learned friend is as a state, he should at least with the greatest respect, should rest somewhere where there should be and in 37 the observation is that you can't go on litigating.
Yes.
Your lordship may just see this, then one thing your lordship may observe, because today even the second point which I may bring to the notice of this court, that way the execution proceedings have been conducted. No affidavit of assets have been sought. There have been no pre-procedures, and directly the executing court.
That was not here. That was not here before this court, Mr. Pandey. You can't expand your arguments that way. We'll pass orders. Yes.
Well, I'm grateful. I'm grateful.
You might get a minor concession at a time. That's all. Otherwise,
You must be grateful for that.
yes.
Also protect our rights.
The thing is that the chief engineer of the State Department has constantly. That undertaking has been left open. Every right in contention has been left open by the
Yes. Right.
And the department is constantly to
Yes.
the ministry. But if the ministry is not ready to release the funds, the chief engineer cannot pay from his own pocket.
Item number
Would
3.
like
Yes.
Great.
Your Lordship, I am LD assistant of MTC. And
What happened? Why not comply with the
departmental
order?
proceedings were drawn against
Completed.
me.
I have to say instruction.
You get instructions first. Mr. A. Moomin at the outset submits that he may be allowed to obtain instructions before notice is issued. So, appearing on behalf of the contemnor. How can he appear without notice being issued? Contempt matter is personal. Anyway, we will overlook that. Let him then heard Mr. Datta issue notice. Mr. Moomin accept notice on behalf of the respondent. He prays not to obtain instruction within
3 weeks.
no 2 weeks. Enough means this is thereafter.
Item number 4.
Wait, please, Your Lordship. Here, Your Lordship, this is Akang matter. Under the Dambu Akang, since time immemorial, there existed 2 separate Akangs. That
Which
is,
Aking is this? Dambu.
yes, Your
Dambu.
Lordship. And there are 2 separate Akangs under the Dambu Akang. That is, Watisa Amati Akang and Milgiri Amati Akang. But they were not segregated nor registered by the GHDC. So Watisa Amati Akang in the year 2006 got registered and segregated themselves as an independent account in the GHDC. Thereafter, the petitioners, since the petitioners were also similarly situated,
You are appearing. You are returning whom? Watesa or Milgiri?
I'm appearing on behalf of the Milgiri Amati Akang.
So Watesa got separated.
Yes, Your
I mean, they got their own boundary.
Lordship.
Yes. And what happened?
So, since the petitioners were also similarly situated, Akang, they have also filed an application before the Court of EM. But their application has been rejected. They have filed an application to demarcate and segregate.
On what ground
the Akang.
rejected?
On the ground that this Milgiri Akang does not exist.
Never existed, or does not exist.
On the, but
Where
they
is
have
that order?
rejected. But they have rejected without following the principles of natural justice, Your Lordship.
Where is the order?
This is at page 29, Your Lordship.
29.
This is the first order, Your Lordship. Our application which has been
29
rejected.
by the EM revenue.
Yes, Your Lordship. That is the respondent number 4, Your Lordship.
What does it say? 27 to 2020.
Yes, Your Lordship.
Yes. Now the main content is to determine whether there exists any amati hacking. I don't understand this. When did the begin? Yes, just explain this order. What happened? Why is he rejected? 29. It's 27 to 2020 order, correct? Yes. But this is a Amati Aking.
Yes, this is Amati Aking, Your Lordship.
We talk about Milgiri. Where's Milgiri?
We have annexed the genealogical tree, Your Lordship, of the Ramsar Milgiri Aking, Your Lordship. This is the map that is at page 15, Your Lordship.
No. Come back to the order. From time memorial, what is it? Okay. What is the? So where is it Milgiri mentioned in this order? Now you are claiming who Dingal Mumin? You said Amati has already been demarcated, correct?
It's the actually, Your Lordship, what is Amati Aking and Milgiri Amati Aking are under the Dambo Aking, whereas what is Amati Aking has already been registered and segregated from the Dambo Aking. So
no, 1 second, just go slowly. Let's just let the court try to understand. Now you say Watesa Amati Aking is one and Milgiri Amati Aking is one, right?
Under the Dambo
under this big Aking called Dambo Aking, right? Now you say that this Watesa has been segregated,
yes, sir.
Correct? Then you prayed for getting Milgiri's
to separate it, to segregate
yes. But in the order it doesn't record whether it's Milgiri or whether it's Watesa. Where? In this order you're citing. It just says Amita Aking.
Impugn order, Your Lordship.
Impugn order, correct. Where does it say? It says that there don't exist any name of Rangsa Milgiri. That is what you agree with. All parties, this submission of the opposite party. My problem the King Bomna did not exist any name of Rangsa in the entire state of working. So now remain contest with the court determines whether there exists any Amati Aking of Dingal movement by name of Rangsa Milgiri. That Milgiri, okay. Milgiri is him. Current survey in according to his map on the presence of the further son that commissioners and so that's only the existence is no appeal for agree after 90 years. So 90 years ago they decided Milgiri does not exist. You're trying to revive that dispute now.
But in the year 2006, Your Lordship, this Watesa Amati Aking has already been registered. So
right, now your quarrel with Watesa, you say that Dambo Aking is the main Aking. Now Watesa, it's been demarcated, you want for Milgiri, that's all.
yes,
Correct. And they say that Milgiri doesn't exist. So how are you the Nokma of Milgiri? No. Do you have a geographical chart to show that at any point of time you were Nokma? Or anything to show that there's a continued you agitating for your rights. Anyway, you appeal against this order also. or no?
After this order, we have preferred an appeal before the Court of CEM, Your Lordship,
Yes, what does the CM say?
which is at page 32, Your Lordship. That is the impugn order passed by the CEM, Your Lordship.
See, there's a now. Here, Mr. Day.
They are reopening the case. My lord, may kindly see the last paragraph of the EM order on page 30.
Yes.
It can be observed that the instant petition is bad in law and is barred by the principle of res judicata. Now, why he is saying so, that is be more clear in para 12 of the CEM order, page 33.
Yes.
Para 12, if my lord can.
Yes.
That since Dumbo Aking has been decided and settled by the Deed and Deputy Commissioner, therefore the EM cannot unsettle or make any change in this regard. Moreover, the executive member in charge land and revenue is equivalent to DC in view of the Garo's Urban District Council Land and Revenue Regulation 1954. Therefore, the appellant cannot bring the matter before the EM, which has been once decided settled by then DC in the same capacity with EM, that is IC in charge land and revenue. Since the impugn order of the EM has not been vitiated by mean, but he has already rejected the petition of the petitioner. They have rejected, my lord, but Deputy Commissioner has rejected. They are trying to reopen it after a period of more than 70 years, my lord. 1925.
Yes. So it got so. See, the thing is that there might have been Milgiri Aking, but the thing is that it was never pursued by your forefathers. That's the only thing, and it's a dispute. If you want to raise a dispute again after so many years, it'll be very difficult. And on top of that, for Bada's order shows that even the Dumbo Aking, they are opposing your prayer, saying that is not doesn't survive anymore. But it did not object to what's the other one? The 2006. The what is that? They didn't object to that. They objected it to yours now.
Your Lordship, but we are being aggrieved by
Now
this
are
orders.
you trying to rely back the order? Was the 27 order, 925 order? Is it here? You approve that order. If the 25 order somehow says that yes, there are two Aking within Dumbo Aking, that's Milgiri and this Watesa, then maybe as something. But then anyway, let's issue notice. Hertz also issue notice. Returnable in 4 weeks. Only on that point, you produce that order. Mr. SD is present. We have response 124. No notice required further. Please take step for issue notice on 5 and 6. Yes. List after 4 weeks. You produce the order, Mr. SD or the parties to try to produce the order dated. The GD Walker's order?
Yes, I will do that. I will produce the record inside.
Yes, Mr. SD undertakes to produce the records.
Just produce the record. Then we'll see, my lord, whether affidavit will be required or not.
Number 5.
This is a writ application being filed by writ petition being filed by the petitioners for the employees of Meghalaya Urban Development Authority, my lord. And
Meghalaya?
Meghalaya Urban Development. The only grievance that they seek to agitate before your lordship is that, my lord, they've been deprived of their allowances. They have been provided only with the basic minimum pay. They have been deprived. They have not been provided with allowances such as DNS allowances, HRA, etc., etc.
Okay. Others are getting.
The others are getting, my lord.
Are you regular employees?
I'm not a regular employee, but then, my lord, that Jagjit Singh matter, in fact, on the earlier round of litigation, my lord, the respondent Muda had given an undertaking, rather a statement, that they were considering the same issues we had come up with. They gave an undertaking of the court that their grievance will be looked into. And on that ground, my lord, the writ petition was disposed of. Now, my lord, after the disposal of the writ petition, they passed an order saying that they will be provided with a minimum pay scale, wage salary as per the 5th pay commission. Now, when they gave the furtherance to that order, my lord, when they acted, my lord, they gave us only the basic pay, leaving aside the other.
For using the surname Nongrum because neither of his parents belong to the Nongrum clan, Your Lordship.
Okay.
So thereafter, Your Lordship, the complaint was looked into and the petitioner here was asked to come to the office for verification. And then, Your Lordship, after all that, Your Lordship, he had come for verification on several occasions also, Your Lordship. But then he was asked to produce no objection from the Nongrum clan. But that has not been complied with till date, Your Lordship. So that is the reason the scheduled type certificate has not been...
How old is he now, the petitioner?
Now she is about to retire, Lordship.
But can he make do without the scheduled type certificate, let him process the pension papers in the meanwhile?
Lordship?
Let them process your pension papers in the meanwhile. I mean, you can produce it later on.
Yes, Lordship.
Subject to the proceedings that are undergoing.
Lordship, at least some direction, Lordship.
Should not hamper your...
Should not hamper that, Lordship. Because it has really hampered, Lordship, with this. And even if they go with that also, Lordship, the lineage check is very clear, Lordship.
That's up to the other authority.
Yes, Lordship.
One thing that the only concern is that you're retiring at the end of the month.
Yes, Lordship.
Yes. Is the scheduled type certificate necessary for settlement pension dues?
Yes, Lordship. That's what they had demanded, Lordship.
No, why? No, they honor the originals, but is it necessary? Does it add to your pension? No. Whatever your entitlements, you're entitled as per your post.
But this is not what the department is doing, Lordship, because they had said that without this you are not, you will not be getting the pensionary benefits. So submission of these original.
Your Lordship, here several communications were made to the office of the petitioner also, Your Lordship,
which we have
to ask him to appear before the scrutiny committee.
No, I mean regarding the objections. Who objected?
Your Lordship, the complaint was made by Agnes Kashiya.
The complaint was by the, that is what I got to know, Lordship. The complaint was someone who is not even related here, Lordship. And then if even on that, Lordship, on that note also, they come from the Nongrum family, Lordship.
Who?
The petitioner here is a Nongrum. The mother was Nongrum. But I do not know what was the complaint since I don't have the copy of the complaint, Lordship.
They were never served on you?
No, Lordship.
That means it's a cause of action of the petition then. It says here, Neera's mother or father are tribals. This is received from the election department.
But Lordship, whatever, it was from 2018. I've been trying to get this, Lordship. They should have, at least if they had rejected, they should have given me the reason, Lordship.
Your Lordship, we can file an affidavit, Your Lordship, by Tuesday to bring all this.
Can you file by Tuesday?
Yes, Your Lordship.
Then when you're retiring?
On the 31st, Lordship.
We file by Tuesday, then file by Tuesday, we'll dispose of on that day. Yes, MSZ Nongkari has produced some written instructions today which indicate which show that the delay is due to proceedings that are pending before the Deputy Commissioner as to the entitlement of the petitioner to a tribal certificate. She prays is allowed to bring the same bring the same record by affidavit. His list on Tuesday is expected by the foreign date after it will be filed. Yes. Better she'll get a copy also. You can see.
Main list. Item number 1.
We settled?
No.
Failed?
I had done my best, my lord. I could not convince the family, entire family.
Is regarding our house that
house now, the appellant had taken by force, occupied house.
I have no idea, Your Lordship.
You have no idea, meaning you said that last time, Mr.
Yes,
Jyosa, because of submits a certain process still underway. That's your submission.
I have no idea about the occupation, Your Lordship.
What happened to settlement? Failed.
Settlement, Your Lordship, a notice was sent to the petitioner by the headman, Your Lordship. But unfortunately, the petitioner was sick, Your Lordship. But she could not.
But means the appellant, Santimai Mutliang, got sick.
Yes, Your Lordship.
You're the appellant.
Yes, Your Lordship.
Then you're the counsel. You couldn't tell her that it's. They say that it's failed. There was no meeting.
They
avoid.
They even refuse to talk to each other.
Fine.
I tried to convince them.
Then we'll hear it the next day.
Okay. All right.
Yes, parties submit that the settlement talks have failed. As such, this is matter after 1 week for admission hearing.
All right.
All right. Yes.
Item number 2.
Your Lordship, we've received the affidavit of respondent 4. Now, Your Lordship, I'm praying for 3 weeks' time, Your Lordship, to file a rejoinder.
This 2 weeks' time is prayed allowed MS Rule how for petitioner to file a rejoinder affidavit. Yes.
Item number 3.
It appears the proceeding is completed and it will be posted for hearing.
That's Mr. Hassan. He's filed affidavit.
He filed.
Yes, party submit the proceedings are complete. Only this matter for hearing and so on. So, yes.
Item number 4.
The respondent are yet to file affidavit.
Please, Your Lordship. Your Lordship, only take some more time. You will give Your Lordship to file the affidavit.
1, 2, 3.
You
You filed yours.
No, Your Lordship.
Why? How many times you've taken? This is long time. How many times you've taken? How many occasions? Since May is in pending, MS and Raji has been consistently asking for time. So also responding 48. Now we're sitting in end of August. Yes. Yet again another prayer is made by MSN Raji for 1 to 3 and MSP Biswakarma for 4 to 8. Further time to file affidavits. It is noted that consistently time has been sought since May 2023. In the interest of justice, for the 3 weeks time granted, is expected that the next day the affidavit should be on board.
Item 5.
Interim order is there.
Yes, Your Lordship.
Until for the orders.
Yes, Your Lordship.
Your Lordship, we filed our affidavit yesterday.
Yes.
We have received today. Today you have received the correct copy of the
Very good.
affidavit. So we will go through. If required, we'll file a small rejoinder.
Yes, Mr. SD submits that yes, receive the copy of the affidavit files to respondents, and that be allowed 2 weeks to file the rejoinder. This is after 2 weeks.
Obliged, Your Lordship.
A rejoinder, if any.
6.
Please, Lordship. Lordship, I pray for some more time to find my...
Why this is that mining matter?
Lordship, the SOP matter.
Why?
Lordship is being vetted by the Learned Advocate General, Lordship. Lordship, 1 week's time may be granted to...
How many times you sought?
Oh.
What about other respondents?
District Council also used to file their affidavit.
Of course.
Your Lordship, I've been informed I'm here to have.
You're not filing affidavit.
Lordship is 1.5, which will not be filed.
Why 5 won't file?
Your Lordship, that's my instructions.
No objection is not necessary anymore from District Council.
Your Lordship, that's my instruction, Your Lordship.
We don't know whether required or not. That's only instruction.
Pardon, Your Lordship?
Only instruction, you're not filing. Very good. MS Room Thao for respondent number 6 and
I'm for respondent number 7.
Yes, C. Nong Cloud on behalf of respondent number 5, or other way around. MSC Nong Cloud on behalf of number 5 and S. Room Thao for number 6. Submit that no affidavit forthcoming from their side. Stop. The state response is represented by Mr. H. Karonlang and who else is there? And Mr. S. number 7. This GHDC by Mr. S. Day. Pray for further how much time?
3 weeks, madam, so that positively we'll file it.
Pray for 3 weeks time. As prayed, 3 weeks time is granted, expected at the next date. Same thing, no point. 3 weeks time as a final opportunity. Failing which will impose cost.
7.
Please, Lordship. Lordship, I've received the complete affidavit in opposition just yesterday. I need some time to peruse the same as to whether rejoinder is required or not.
Yes, sir. After it has since been filed by the respondents, MSP Agarwal, please will out 2 weeks time.
Lord, if it could be...
To file rejoinder, if any. 1 week time. 3 weeks.
My Lord,
Why?
because I'm not keeping very well these
Okay, 3 weeks time to file rejoinder, if any.
days.
Item 8.
May I please, Your Lordship? 8 and 9 connected matters, Your Lordship. I have prepared their affidavit and I have sent also, but the director needs some clarification regarding some new subsequent development is there. So I need some more time to correct the affidavit, Your Lordship.
You're opening for?
Opening for item number 9.
You file affidavit? Similar affidavit. What's the matter about?
It's about regularization, my lord. Initially they said that my name has been forwarded to the cabinet for regularization, my lord. I'm a chokidar in the school, my lord. But subsequently, my lord, they have not done anything, my lord.
So you file affidavit.
Yes, Your
Further
Lordship.
2 weeks time granted the respondents to file the affidavit is
Much appreciated.
8 and 9 same order. Further time is prayed.
10.
2 weeks further time is prayed. Not 2 weeks.
Wait, please, Your Lordship. In this case,
Yeah.
the respondent are yet to file their affidavit in opposition.
My lord, we are still waiting for instruction, my lord, here in this matter. I represent 1 to 4 state respondents.
1 to 5.
1 to 5, my lord.
What about 6 to 8?
Your Lordship, I'm appearing on behalf of Ms. P.S. Mongri for respondent number 6, 7, and 8, who prays for 2 weeks' time to file a counter affidavit.
The fresh matter.
My lord, it's a fresh
Further 3 weeks time granted the respondents 1 to 5 represented by MSR Kohli and 6 to 8. Who was your name?
M. Lakman.
And 6 to 8 by M. Lakman to file affidavits.
Highly obliged.
11.
Wait, please, Your Lordship. Your Lordship, in this matter, we're still awaiting instructions. So I'm praying for 3 weeks' time, Your Lordship, to file our affidavit.
3 weeks time is prayed allowed to respond for affidavits for that time.
12.
As per the last order, my lord, 10 days time was given to me for filing my affidavit. Well, I've sent the affidavit. I'm just waiting for the
Sent it
vetting. District Council, my lord.
I thought Chandrayan.
No, my lord. My lord.
But that's the GHDC, that's the whole problem. You never file affidavits.
No, my lord. Within next Friday, I will file it, my lord. Positively. And this is 2023 matter, my lord.
There is some.
It's a very small matter. That's why you give 10 days. It's just to bring record resolution of public meeting.
Yes.
Showing the result of the election. You have submitted that.
Yes.
That the elections have been done.
Yes.
You only have to be 1 page instruction.
My lord.
What affidavit is necessary?
But my lord has directed me to file an affidavit. Small
Short,
affidavit.
you
Yes.
had requested for that, Mr.
Yes,
K.
yes,
You said, I'll bring a short affidavit just to bring on record the result of the elections. That's all. What happened to the elections?
No, not election. There was a selection among the village, my lord.
I mean,
sent
public
the
meeting to
proposal.
Gaumburayas. What happened?
They have, villagers has conducted an
You got the instructions still with you there?
No, my lord, one I have shown, my lord. This was what we have received. This was what we have received, but only for the vetting of the affidavit. Affidavit has to be vetted from this.
Okay, Mr. S.D. submitted as the affidavit has not been signed as yet, he could not file the same. Not for the 1 week's time.
Well, I'll do it positively.
Hearing, item 13.
My lord, the issue involved in this case is cancellation of the 2 increments given to the petitioners.
Cancellation of
the 2 increments.
Increments
after 20 years. After 20 years. My lord, there is a lordship. I may take the first annexure where the next draft rules. Under the draft rules, he received these benefits. My
draft rules is not. We cannot go by draft rules.
My lord, I'll show lordship permission how they acted upon. The draft
Where
rules.
is that?
Well, on page number 19, annexure 1.
Which they working as forest guard?
He was working as a forest guard.
Okay.
Now, this is the the draft rules. It calls the Forest Guards School of Meghalaya Training Rules 1994. Now, under this, we can come to page number 26. 26, relevant portion.
Page 26.
26.
Who's appearing for the respondents? You ready?
AG is appearing.
Lordship, I'm there.
You ready?
Lordship, yes.
That's what the court wants to hear. That's all. Not after he's finished his arguments to say that you pray for time.
No, your lord.
Some counsel are very expert in doing that. Yes.
Page 26.
Yes.
Subrule 3, may I read?
Rules?
Subrule 16. Subrule 3 of Rule 16. It says, the candidate securing honours certificate shall be granted 2 additional increments, and those securing pass certificate shall be granted
securing
1
honours certificate shall be granted 2 additional increments.
Yes,
and those securing pass certificates granted 1 additional increment.
1 additional increment immediately after passing out of the training. The increment in this case would be given with effect from first of the month in which the passing out ceremony is held. The trainee who stands first in the first examination shall be awarded a prize in kind to name as Forest Minister's Prize each year. The expenditure on the prize, the value of which shall not exceed ₹1,000 only, shall be met from the annual budget of the school. She would also be promoted to the next higher rank, that is, the rank of Forester 1, in case the trainee is of matriculate, and to the rank of Forester 2 in other cases. Now, this was, my lord, number 6 also, may I take number 6. The result of the examination, the advance increment as under Subrule 3 above, and the result of the stoppage of the increment under Subrule 2 above shall be entered in the service book of the trainee concerned by the principal of the school. He shall also make recommendation to the concerned authority for taking action for promotion to the next higher rank under such and such. Now, this was amended in 1996. May I take to that amended 1.
These are draft service rules.
The draft service rule, and they acted upon. Well, I'll come back. Now, Lordship, we come to page number 30.
It's 94.
Well, page 30. Now, by this letter, they have shown that the amendment was done. Subrule 6. I am to inform you that the Rule 15 and Rule 16 of the Forest Guard Training School of Meghalaya has been amended, and a copy of the amended rule is enclosed for your information. Necessary action, Lordship, may I say, necessary action. Now, may I come to the amended 1, page number 33.
Yes.
My lord. Here, page number 33. Rule 16(1) says, candidate must secure at least 60% marks for pass certificate. Those obtaining 80% above or more will be awarded honor certificate. Candidates failing to secure minimum pass marks will be declared fail and will lose 2 consecutive increments. with recurring effect and will not be eligible for promotion to the higher rank. But others are same conditions. Now, the writ petitioner, he secured the first position also, as well as, my lord, the honor certificate. Lordship, Lordship, we can come to page number 38, my appointment letter. Page number 38. My lord, by this he was appointed on 7 April 1998. He was appointed as a forest guard, serial number 1, Sri Boniface Karpanga. My lord. Thereafter, my lord, he joined. My lord, Lordship, kindly come to page number 40. The marks secured by him in the training school. Page number 40.
1 second, go one at a time. Page 38 is your, this is the results.
Well. Appointment of mine.
Yes. This is
appointment of mine.
38.
Well.
Is dated 7/4/98.
Yes. I was inducted in the service.
Yes. Then?
My lord, there, my lord, in 2001, I underwent for this training and research sheet, my lord, page number 40. 40. And serial number 2 is a writ petitioner. And he got, my lord, stood first position amongst the forest guard.
So who's the one who came first before you?
Well, he is the other, my lord, he is the forester 1.
Okay.
Among the forest guard and the serial number 1. Now, page number 41, this certificate also issued to him.
Yes.
This is to certify that Sri Sansaj, son of Sansaj, has successfully undergone the basic training course in the 7th
honor
batch.
certificate.
So, honor certificates. And his highest mark in the individual subject also, page number 43. The certificate is issued by the principal, by the school. Now, in view of this position, my lord, he was granted the 2 increments, page number 45. Page number 45. May I read with lordship permission? That it is such, on completion of the 7th batch forest guards training, such, and having awarded an honor certificate to advance increment of ₹50 only is hereby granted to Sri Sansaj, raising his as above Sansaj. Now, these 2 increment was given, raising his, my lord, from ₹2,800 to
850.
That one, and 2,850 to 2,900.
From 250 to 2,900.
Yes, with effect from 2001.
Yes.
So that was given to him, and my lord, may I come to the page number 47. The next, there was one letter issued by the department where it says, my lord, may I take lordship attention? So, with reference to your letter quoted above, it says, I am directed to say that the benefit of 1 advance increment admissible to Forester Grade 1 on successful completion of training in Forest School as incorporated in the MOP 1975 is deemed to be still in operation as the government has now allowed the system of advance increments to continue with the Sansaj pay revision, subject to the existing terms and conditions. No separate government orders are necessary for retrieval of these increments. Now, under the existing rules, orders, advance increments are allowed to government employees for possessing higher or an specialized qualification than the prescribed minimum qualification for appointment to posts under various departments of the government. A Forester Grade 1 who has passed the department training is deemed to have obtained a special qualification and therefore qualifies for grant of 1 advance increment. May I skip that one, the last one. You are requested to take necessary action accordingly and to also ensure that the provision of advance increment for the Forester Grade 1 indicated against the post in the Sansaj should be incorporated in the relevant service rules, if not already done so, which may be similar to Rule 19 of the Meghalaya Health Service Rules. Now, here it talks about the Forester 1 only. It doesn't talk about the Forest Guard. We are not here. But now, Lordship, kindly come to the other letter, page number 49, my lord. Page number 49. Now, petitioner requested for, my lord, giving him promotion under that draft rules. He entitled for promotion to Forester 1, but that was denied to him. So 2006, he requested to the department to consider for that. Now, page number 50 or so, my lord, this is the same letter, similar request. And later on, my lord, page number 51, he was promoted.
To Forester grade 1?
Yes, in 2012, my lord. His name is serial number 12. He was promoted. See, he passed on 2001, but promotion was given in 2012 after much delay. And thereafter, my lord, the writ petitioner joined the promoted post in 2012 itself. And may I take the page number 56, MSCP scheme. MSCP schemes.
Yes.
Now, MSCP scheme, my lord. Point number 7, my lord, at the bottom. Let me take Lordship attention to page 7. It says the eligible employees may be allowed to the benefit of MSCP scheme on completion of 10, 20, and 30 years of service, respectively. In other words, the benefit of placement under the MSCP scheme should be available to eligible employees with effect from the first day of the month of January or first day of the month of July, as the case may be, following the date of their completion of 10, 20, and 30 years of service, respectively. Now, my lord, he was appointed in 1998, but more than 10 years he did not receive, did not get any promotion.
What is your prayer? Are you seeking even MCAP coverage also?
Yes, one prayer.
Apart from the increments also?
My lord.
There are two parallel cause of actions here, trying to advocate here.
My lord, two prayers are there in the writ petition.
Yes.
So, he was promoted after, he was given the promotion of Forester 1 after 14 years. So, for previous 10 years, he got the MSCPs. Now, he's claiming for the second MSCP.
22.
My lord. 2012 to 22. Well, he did not get. Now, this is the policy. May I come to the other point, my lord? That is page number 64. 64. My lord, it says it is notification, my lord, that in exercise of the power conferred by proviso to Article 309 of the Constitution of India, the Governor of Meghalaya is pleased to order that the following amendment shall be made in the pay schedule appendage to the MOP, such published with Finance Department, such. In the said schedule, under the head Forest and Environment, the following entries shall be inserted under column 5 against the sunset. It says Forester grade 1. 1 advance increment after completing departmental training course from Forest School. So this is issued in 2018.
No, this is the revision of pay rules.
Madam, and the amendment, madam.
See, the thing is that now it is an amendment revision of pay rules, Meghalaya Services Revision of Pay Rules 2018, correct?
Yes.
So the pay schedule.
Madam.
Now you're seeking to base your case on the basis of the draft rules.
Madam. Now, this letter is relied by the department. And on the basis of this, they are taking away my increments. Therefore, I'm referring, madam.
So that is why the amendment says that the grant of advance increments have been related to the existing terms and current prescribed relevant service rules.
Yes.
So if you say the grant shall be regulated as per existing terms, that means you are trying to say that those service rules, draft service rule by which you were given these two advance increments should be continued.
Madam. Because that 2 increments given to me was on the basis of the draft.
Correct.
Under the service rules.
No, this one, even this says, it says, see, 1 advance increment after completing the departmental training course from Forest School. Yes. That doesn't concern you, because you're concerned with the other part, 2 advance increments.
Yes.
The grant of advance increments shall be regulated as per the existing terms and conditions prescribed in service rules. Now, Mr. Shurai, there's no service rules as yet.
No, Your Lordship. No. Let me finish, Your Lordship. I please my case.
Yes. No, I'm just asking.
Yeah.
Yes.
And this advance increment has nothing to do with my previous 2 increments. But I secured that 2 increments because of by virtue of the good performance in the training school. And this rule talks about the advance increment. It's altogether different. Now,
that's what the school is saying. It's totally different. Passing for school is different.
Right.
You are granting up to advance increments on totally different considerations.
Right.
Correct.
Lordship is correct. And now by this letter, page number 65, they are referring to this letter. May I take a Lordship? Now, it says, 1 advance increment and 1 extra increment of 24 batch trainees after completing department training course. It says, with reference to the letter of the subject cited above, I am to inform you that Forest Guard School of Meghalaya Trainings and such is yet to be formally approved and notified by the government as it appears, and therefore it is still in draft form. It is, however, considered as a guiding principle. It is very important, my lord, their intention, for smooth running and conduct of basic forestry training of the frontline staff, namely foresters, forest guards, and such. In this connection, pending notification of the training rules, 1 advance increment can be granted only to the forester 1 who have successfully completed basic training course in pursuance to government instruction by such, my lord, and notification such, 2019. And notification 410 is page number, my lord, 64, and the letter 69 2002 is page. It is available in page number, my lord, 47, where they talk about for inclusion in the service rules. Now, in the case of forest guards who have successfully completed the basic training course, 1 advance increment may be granted only on their promotion to forester 1. A copy of the government letters and such is enclosed herewith for your reference. However, no extra increment can be granted to any staff on the ground that he or she has successfully completed the training course with honors.
It has been taken away from you,
my lord. So
that's all it is.
They are issuing this letter and try to take away my benefits, my lord. And they have issued in 2020. But after 20 years, my lord, they are issuing this, and this letter do not say it is a retrospective effect. It is a prospective in nature. Now, later on, my lord, page number 69, they have issued the impugned order. Impugned order, page number 69 is the impugned order. July 2020. After 22 years, they have taken away the benefit merit. In modification to this office, number.
Sorry, where are you reading? Sorry.
My lord, page number 69.
Yes.
69.
Yes.
This is the impugned order we challenge, my lord. In modification to this office orders and such, 31st/10/2001, this is the day where they have given me the benefits, my lord. And as per government letters and such, 16/9/2002, that is, my lord, the letter for incorporation in the service rules. And such, my lord, dated 19/3/2020, 2 advance increment which was already granted to Sri Boniface, Forest Guard, raising his pay from such and such with effect from such is hereby cancelled. An annual increment is hereby granted as follows in the such. Now they have taken away that benefits and restructure my benefits. Now I'm having grievance with this, madam, because my basic grievance is that the benefit was given to me under different circumstances, under the draft rules, and the letter itself says that the government is intended to enforce, to notify this. To notify, I'll place one judgment to substantiate my argument that once government has intention to act upon and one action taken by them, it is permissible, madam. So under that draft rules, 1994, they have given me training, and not only me, many, my lord, more than 28 batch training has gone, and many got benefited. Now after 20 years now, they introduced this, and they are trying to take away. So my benefits given to me was not under the service rules, not under the MOP also, is under the different draft rules. So this cannot be taken away, and government has the intention to follow these rules. So one decision, my lord. I'll place the latest one. My lord, 2005 volume 8 SSC. Page number 394. 394. Relevant para would be my lord, para 23, 24, and 28.
Para?
Para 23 and 24. 23 and 24. My lord, it says, my lord, as has been noticed by this court in Abraham Jacob and such draft rules can be acted upon to meet urgent situation where no rule is operating. In the High Court of Gujarat versus such, now, my lord, it is now right that draft rules which are made to lie in a nascent stage for a long time cannot be the basis for making appointment or recommendation. Rules even in their draft stage can be acted upon, provided, my lord, there is a clear intention on the part of the government to enforce those rules in the near future. Now, by the letter which I've read out with Lord's permission, government has intended to follow even the introduced amendment and circulated to Department for necessary action, and subsequent letter also they say that this draft rule is a guiding principle. And accordingly, they have taken action under that rules. So at this stage, 20 years, out 20 years, my lord, they cannot, my lord, take away these benefits. And with regard to my second prayer of MSCP, I made a categorical statement, para 13 of my petition, my lord. Para 13.
Para 13.
Para 13, my lord. Para 13 of my petition. Well, this should be with effect, should be effect from 2012. So I make a statement here that I entitled for the second MSCP. From 2012 to 2022, there is no promotion for me. So I prayed for that. Respond to this, my lord. State has filed affidavit. With regard to that, my lord, may I just state, Lordship, page, para 13 of the state affidavit. Para 13 of the state counter affidavit. The reply given by my lord. With regard to the amendment made in para 13 of the petition, answering deponent states that process for granting MACPS in respect of the petitioner has not been completed, as the advance increment granted to him in 2021 has to be regulated first as per the sentence and such. So they are not denying I entitled, but they said they want to settle with my increment first. So, my lord, my humble submission is, admittedly there is no service rules. In the absence of service rule, draft rule was already in place, and they have demonstrated their intention to follow, and they act upon also. And not only me, many others were received these benefits. So after 20 years down the line,
after 20 years,
my lord, they cannot take away at this point of time. And I'll be retiring in the month of October.
No, once it lowers your pay scale, Mr. Shulai, it amounts to some sort of a punitive action.
This is a wrong run of increment, your lordship. Then it was detected, your lordship. That is why the impugnment has been issued, your lordship.
Okay, yes, what do you have to say?
When the wrong is detected, your lordship, the government is the government has the power, your lordship, to rectify.
Once the wrong is detected, make it more wrong or make it more right.
The government has the power, your lordship, to rectify the wrong.
Yes.
Lordship, kindly make this is your lordship. Lordship, first I'll take to lordship to the annexure 17 at page 69. That is from the writ petition. That is the impugned order, your lordship.
Yes.
Kindly see, lordship, he has been given that increment, your lordship, on 31st 2001, your lord.
69.
Lordship, yes, 69. Why, Your Lordship? Why this order has been issued as I have submitted? Because it was detected, Your Lordship, that it is wrong. It is.
That means that in modification, the office order by way is granted the first 2 advance increments.
Lordship, yes.
2001, is that correct?
Yes,
Sorry,
Your
sir.
Lordship.
But
Lordship, Lordship will come back to page. Lordship will come back to page 45. That is the first increment, Your Lordship. Then, and as per letter dated 16/9/2002 and CF number so and so 19/3, 2 increment which was already granted to so and so for with effect is hereby cancelled. Then, Lordship, 16/9/2002, if Lordship can find it at page. That is
page 47.
Page 47. Page 47, Your Lordship. I'm highly obliged, Lordship. Lordship, kindly see this instruction of the government, Your Lordship, relates to the forester, not to the forest guard. Here, the petitioner is a forest guard, Your Lordship. It's very clear, Your Lordship. Lordship, kindly see the second
paragraph. He has submitted also.
Your Lordship.
He's saying that there should be some kind of a parity then, whether it's forest guard or foresters.
Lordship,
he said you've got to take according to ensure the provision of advanced increments, forester grade 1 indicated of post. He said why is
a forester who has passed the departmental training is deemed to have obtained a special qualification and therefore qualify for one advanced increment. Your Lordship, this letter specifically states, Your Lordship, that this agreement, Your Lordship, after having passed the training, will be applicable only to the forester, not to the forest guard, Your Lordship. The language is very clear, Your Lordship. It relates only to the forester, not to the forest guard, Your Lordship. Because what happened, Your Lordship, the writ petitioner, he was promoted to the post of forester in the year 2012 only, Your Lordship. All this communication, Your Lordship.
So he's promoted to forester grade 1 in 2012.
In 2012, Your Lordship.
Correct. Okay.
So this letter, this instruction of the government, Your Lordship, speak about the.
So you submissions that he's not derived any rights from.
Yes, Your Lordship.
Whatever rights he derived also little is extinguished.
Yes, Your Lordship. Because.
And what are the other submission?
Lordship, because if this agreement is to be granted to him, Your Lordship, even in spite of the fact that he
if
was.
This what in agreement? Okay.
Is not a forester, then, Your Lordship, in that view of the matter, a prior approval of the government is necessary, Your Lordship. Then, Your Lordship, we have filed the affidavit. If Lordship can come to page 9, Annex 1 of the affidavit, Your Lordship.
Page 9?
9 of our affidavit, Your Lordship.
Yes.
Lordship is got it.
1 second. Is it next year?
Lordship, yes. Annex 1, page 9, Your Lordship. This is relating to some people, Your Lordship, in the regarding the initial pay statement, Your Lordship. Lordship, I'll take to the second paragraph, the admissibility, Lordship, of advance increment for passing training as explained in our letter dated so and so 16/9/2002. That means that letter, Your Lordship, we speak about the forester, relates only to forester. In the case of forest guard, grant of such increment should have prior approval of the government. As the question of extending advance increment to the forest guard is still under exemption of the government, the benefit is not admissible to them retrospectively in anticipation of approval.
What you already gave him?
Lordship.
He enjoyed for 20 years.
Lordship, that is, I made a submission, Your Lordship, that was a mistake. That was a mistake on the part of the
what are the consequences of reduction in scale of pay?
Lordship.
What are the consequences?
When it was detected, Your Lordship, that is why that impugn order has been issued in the year 2020.
What are the consequences of reduction in pay scale?
Lordship.
What are the consequences?
Then he has to, Lordship,
you represented, you didn't answer the representation. Or only the affidavit you've shown this?
No, Your Lordship, so far no representation has been filed, Your Lordship.
By him?
Yes, Your Lordship.
Okay, yes. Reduction in pay amounts to? Yes, what about this letter 16 September 2002? The same one, 16/9.
Lordship, 16 September, Your Lordship, 16.
Only against Forester, yes,
which
that one.
Which I have shown you to Your Lordship.
Yes.
Lordship. So it's very clear, Your Lordship, that at that particular time, when this grant of increment has been conferred on him, Your Lordship, he was not entitled, Your Lordship. He was not entitled. He was not entitled. That is why.
Come back to the draft service rules.
Lordship, is only a draft, Your Lordship.
Come back to the draft. What about intention of the government to implement a draft?
It is only a draft, Your Lordship. From the that is why, Your Lordship, the letter dated 16/9/2002, Your Lordship, is very clear, Your Lordship. From this, it can be inferred, Your Lordship, that the draft rule is not being acted, Your Lordship, to confer that benefit. It's very clear. The language is very clear, Your Lordship. Can you see, Your Lordship, second paragraph of that 16/9/2002, Your Lordship? It's a forester who has passed the departmental training, Your Lordship. It does not say about the forest card, Your Lordship. So the intention of the government is very clear.
So you're going to recover the money from him?
Lordship?
You're going to recover the increment from him?
That, Lordship, is for the department, Your Lordship.
It's your mistake.
It was detected, Your Lordship. So as I have submitted, Your Lordship, the government has the power, Your Lordship, to rectify the mistake. We have the power to rectify the mistake. That's why, Your Lordship, so far that MS modified.
Because the draft service rules, it creates a small problem here. Because he acted upon it, which shows that you are tacit implementation of the rules. But as per the training rules, whoever gets honors.
It's true, Your Lordship.
And what's the other one? First.
Then that, Your Lordship.
First, and he passes honors. After he gets honor certificate, he is granted to advance increment.
Because, Your Lordship, it is true, Your Lordship.
It has been implemented because you've implemented the draft service rules, which is like implementing executive instructions.
Lordship, kindly, Your Lordship also will kindly appreciate, Lordship, that the 94 years he got that, that is the admitted fact. But, Your Lordship, subsequently, there was a letter of September 2002, Your Lordship, where the government specifically instructed that only the forest.
How come it continued for 18 years after that?
Lordship, that is
16/9/2002. If the letter issued, it says that only forester, and he's a forest guard.
It was detected, Your Lordship. It was detected, Your Lordship. That's why that we have to rectify, Your Lordship. After
any other similarly situated forest guards with undetected is enjoying till now.
Lordship, once the government detects all this irregularity, we have to, Lordship, we have to rectify. We have to rectify. It is not a pick and choose, Your Lordship. It's not a case of pick and choose. So after, Lordship,
it's a case of pick and choose, you're saying?
No, Your Lordship. It is not, Your Lordship. It's not a pick and choose, Your Lordship. So that then the modified accretion career progressive scheme will be conferred on him, Your Lordship. Once this has been rectified, Your Lordship,
we're not going to touch the MECP because we're not going to mix up two cause of actions in one petition. That's a separate and definite cause of action.
Since
that is a consequential which you can examine, but the thing is that to any positive directions will not come from the court.
The second relief, Your Lordship, it will be examined. It will be.
So he says that 2001 he entered service in
1998. 1998, Your Lordship.
Yes. So you are due in 2008 for your first, which has been given in 2012. So 4 years.
He got the promotion in 2012, Your Lordship.
So now 22 you have to get again.
As a forester.
Because you've exceeded to that, MSCP after 10 years, you gave to 14 years, not done anything. So now 10 years only. You're promoted on
2012, Your Lordship. That is all.
10 years completed in 2022.
On 16/5, Your Lordship. On 16.
So that's the only argument. You got any authorities to show that once it's detected that the government has the power and authority to annul it,
Lordship, then
and deprive like he's acquired. What they say, he's been visited with civil consequences, in the sense that the only weakness in your case is that
Without affording him an opportunity.
No, not opportunity. You have acted upon the draft service rule taking to be sort of executive instructions. So there it specifically says that the person on the honors list who comes first will to advance increments. By virtue of that, you have granted him that. Then there's another communication saying that we are waiting for the approval of the rules. You still continued. 2002, you issued that September notification after he enjoyed another 18 years. So finally, when you recast his pay scale, or whatever, when the other time came for the other increment, then it was detected that he's already enjoying two advance increments.
Yes, that is why that impugnment has been issued.
So even then you gave him the advance increment again. Correct?
Lordship. So that is why it was that impugnment has been
because draft service rules, like generally speaking, okay, we don't go by them, we don't acquire any vested right somebody. But in this case, a bit different.
But Lordship, the letter of
because the only link you can find to him enjoying that 2 advance increment is from the draft service rules only.
Then Lordship, can you see the intention of the government by issuing the letter of 2002, Your Lordship?
No, 2002 is fine. We no problem with that. But the thing is that can it be that 18 years enjoyed?
Because once that has been rectified, Your Lordship, then whatever
that's what will happen. You see, what happened now? Suppose the order comes from this court that fine, he's not entitled. Will you start recovery proceeding against him then?
Lordship will make an observation to that. Lordship will make an observation, Your Lordship.
That he's entitled to advance increments to retire.
Lordship. Because it was a mistake, Your Lordship, in our part. It was a mistake on our part.
So what do you have to say?
With regard to my lord, the new rule is not acted upon. This is incorrect, my lord. The training they have given till 2020, 24 batch is under the draft rules. Continuously they act upon.
Were any other person subsequent to that 2002 notification given the same advance increments?
Well, that I'm not aware. I'm not aware other employees.
Were they given?
But with regard to them, I respond to them.
Before you were they given?
But
before you, your predecessors or your successors?
With that regard to, I can take instructions, but they must be. And the draft rules still continue to act upon till 2020.
We take instructions which is further.
And secondly, my lord, the London AG said it is a mistake, detected. The affidavit did not say anyway. The affidavit did not spell out that on which year they came and detected and they took action.
In 2020.
Nothing in the affidavit. Well,
you see, the thing is that the least you can do is to give a notice that that there is a proposal because it's been detected, so on and so forth. And then he has to be given a chance because reduction in pay scale amounts to a sort of a punitive kind of like suppose for some mild misdemeanor he's been charged, right?
Lordship, yes.
Suppose even the deprivation of increments also amounts to a punishment. So he is being, in fact, indirectly being a punishment for something that he didn't do. Yes, so civil consequences has been visited upon him. That's the thing. So the correct procedure because the reduction in pay is. It's just that it's the thing that mostly you okay on misconduct you give some penalties, minor penalty, okay. Minor penalty, censure, warning, then some other minor penalty will be the withholding of the increment. That's only the troubles of court. Because you don't follow, he's been enjoying and one fine day, he's sorry, made a mistake,
Lordship, as I have submitted also, the government also will, Lordship will grant to that liberty to the government to rectify if the mistake is.
It's not the grant because the government is supposed to be a model employer.
Lordship is true.
Then you find out whether anyone got after that.
Other colleagues, other
employees. Yes, we'll have it after. We'll dispose it off in court next week. It's heard in part. Just after 1 week. Yes.
You'll come after 2 weeks.
You bring some. Why 2 weeks? 1 week. 1 week.
1 week, Your Lordship. I'll try to
get some authorities which allows the state to engage in such an exercise. Yes. Otherwise, draft service rules. Mr. Samuel, so
correct. No one.
You can't derive any, or claim any right. No right is
unless they make a point.
Apply your lordship.
14.
May it please your lordship. Lordship, this matter is regarding the statutory the dues that were supposed to be paid, lordship.
I'm confused. Marbanyang. It's not on Marbanyang. Is it escrow account? No.
No, lordship. That's listed on Monday. This matter is regarding the non-payment of dues, lordship.
17. Hold on. 17. 17, 18.
Lordship, on the last occasion, senior counsel. Lordship.
Yes.
Lordship, on the last occasion, conducting senior conducting counsel had argued that the non-response, the lack of response from the respondent corporation would actually be considered as a continuing cause of action, Lordship, and we had prayed that we'll list authorities on that regard. Lordship, we found 3 authorities, but I'm praying if some time may be given to us to examine those 3 authorities, Lordship.
What about the records, Mr. Karwanna?
Lordship, I have the records, but then, Lordship, if I may, Lordship, the arguing counsel, Mr. SIA, is on legs before the other court. Lordship, if the matter can be taken.
Number, there's only one court sitting.
Lordship in Delhi, Lordship.
Just for the records, meeting 28 August 2014, what does it say? So this actually fortifies the case.
Lordship, I'm not privy.
Okay.
Can I have it up?
I will take it on record. Mr. H. Lang, pursuant to order dated 14/8/2013, has produced the minutes of the meeting held on 28th or 26th. Is this the right one? We asked for 28/8.
28.
This is 26/8. Oh, it's 28. Right. Yes, wrongly written on top. Has produced the minutes of the meeting dated 28/8/2014. Stop. However, he expresses his difficulty to conduct the hearing today due to the absence of the arguing counsel. Stop. MS K.D. Cruz, right? Also prays that some time be given to enable it to come up with the authorities. So, this is a matter after 1 week. 1 week beyond. 2 weeks.
Lordship, I'm praying if this matter may be listed on Monday.
Sorry, we'll have it after 1 week. Yes, we'll give a date to 1 week for further hearing. Stop. The copy of the minutes dated 28/8/2014 is taken on board and made part of the record. Yes.
Highly obliged, Lordship.
15.
I think he'll have to pay him. That's after it's been filed. Yes. Start.
May it please your lordship, due to some personal difficulty of learner DSGI,
he's left the premises of the court, Your Lordship. So if we may
You've
have
heard
this...
us saying Elvis left the building.
He's left the premises of the court.
Have you heard us saying Elvis has left the building?
No, Your Lordship.
You know, you heard of Elvis Presley, correct?
Elvis Presley, Your Lordship.
Yeah, he's supposed to be the king of pop.
Yes, Your
So it was a big concert, in one city. And so many fans after him, so that announcement to be made, So like, still waiting for an encore from Elvis. So the presenter goes on stage and says, Elvis has left the building, thank you and good night. So that's what, so you're saying the same thing here, the end of court. Yes, as High Counsel is not available, this is matter on so and so for you. Yes.
17.
We're praying for time. This matter is listed in here.
Which matters? Corrected matters?
Yes, my lord. Corrected matters.
Mr. Gautam, we hardly get his presence. So we should take the opportunity to, tap onto his knowledge. First appearance.
Today is his first
No,
appearance for hearing.
My lord, this matter is ready for hearing for quite some time. And the issue involved here is very simple, my lord. Whether a notification can take away a right conferred by a statute. That is the limited issue here.
They are the work charge employees, and all are appointed.
They were the
work charge employees.
whose employees?
Work charge under
Work charge. We are work charge employees, my lord. And
but they are all appointed after 1997, which was banned by the government.
I do not know how it was banned.
Banned?
Ban means
That ban is a notional ban. If a ban is given in the government itself,
it was not abolished. What has happened here is,
but they are not entitled for all these
my lord,
benefits.
after the 5th Pay Commission, my lord, the rules of 2018 were enacted. The rules of 2018 provides that the benefits of the 5th Pay Commission will be extended to the work charge employees also. Now, by a notification, my lord, that benefit has been taken away, saying that this the 5th Pay, the benefits of the 5th Pay Commission will only be
to those employees
who are appointed
after 1997 not be entitled to
prior to 1997
benefits of 5th Pay Commission.
Yes, ma'am. The basis of that notification is an instruction, is an executive instruction issued by the government to all the departments that henceforth you shall not make any appointment of work charge employees.
But those appointed prior to 97 as on today all regularized. So they already form part of the regular establishment.
Yes, they are the part of the regular establishment.
What about you? You still work charge?
Yes, we are still work charge.
And the government appointed prior after 97 now is sitting in town 23.
Yes,
it should have been regularized.
Yes, my lord. Either we should have been regularized, or the benefits that has been conferred to us by the Act of 2018 ought to have been given to us.
The Pay Commission itself recommends that the work charge employee will also benefit from the 5th pay. And the rules thereafter, which have been framed, that also provides the same.
It provides for it, my lord.
And so you come prepared. When? Monday?
It may come up after 2 weeks, madam. We'll do it.
Why? Mr. Bara, you'll do the disappearing act, or he'll do the disappearing act.
No, madam. Other day I was talking the other court.
I don't know about any other day. I'm not saying anything. If you have if you have, I'm not asking an explanation. I'm saying parties don't do the disappearing act. That's all.
5th will do, it will be almost 2 weeks.
Yeah, this will matter on 5th. Yes. September.
All
That's
connected to the end of the court.
Obliged.